to look up the
Well,
cases.
yeah, that's true.
In the 80s and 90s, at least.
They can do that, but and of course they could spend the money that way. It's not a very efficient way to dig up unpublished opinions, which may or may not even help you. Clients aren't going to pay for that. The reason it advantages the large firms is because they are frequent litigants. Those firms have hundreds of lawyers, thousands of clients, which means they were parties to a lot of those opinions. They have them in their own offices. They don't have to go to the courts and pull them. They've got them in their offices. And so let's say that you're a law firm that represents State Farm. Well, hell, State Farm's involved in, a ton of, let's say, just car accident litigation. And so if you want opinions on car accident litigation that aren't published, you've got them. You got tons of them. So that's another reason that it advantaged firms with a lot of lawyers and the ability to specialize, because you had all of the opinions that had been issued in your clients' cases in a particular area of law. It was completely untenable for a solo practitioner or someone in a firm with 3 to 10 lawyers. You just didn't have enough opinions, and it certainly wasn't worth the time to go dig them out of the clerk's office on the off chance that something was available. So what happened in the 90s was that lawyers began to bring these challenges, saying that these unpublished opinions violated the open courts provisions. And so the courts responded by amending their unpublished opinion rules to say that you can cite the opinions, but there are 2 things that you have to keep in mind. 1, we won't give them any precedential effect. And 2, if you do cite them, you have to include a copy of it for opposing counsel. So that way you can't have anything hidden. You can't, you can't practice law by ambush. So those are the 2 constraints, that you can cite them, that anybody can cite them, but that you have to provide a copy. And so that along with greater accessibility to Lexis and Westlaw, leveled the playing field a little bit. So those are unpublished opinions. So anytime you run across an opinion that says not designated for publication, not for publication, unpublished, or anything like that, you always need to check your local rules, whatever federal circuit you're in or whatever state court you're in, because courts have slightly different rules about what effect to give those opinions and whether or not you can cite them. Some jurisdictions won't let you cite them. Under the federal rules, you can, as long as they were published, I think, after 2007. So you'd want to check the local rules on whether to cite those opinions. From a judicial standpoint, though, the problem that she identifies is, listen, some of us are subjecting our work to greater scrutiny than others, and that even though you can't keep these opinions hidden anymore, by designating it as unpublished, you strip it of its precedential value. And so even though it's out there for everybody to see, nobody can use it. And so it's still sort of, it's a little bit of dirty pool to overuse that designation of unpublished opinions. And that judges are using that as an excuse or as an opportunity not to provide a full dress opinion that clearly sets out the logic, which is the function of the courts, to not just articulate a result, but also to justify the result. Tiffany?
I think going back to your first point about the advantages, I believe when I read the article, it had mentioned unequal justice and secret justice. So I think that people felt that there was an advantage there, and that the unpublished opinions supported, unequal access to justice like secret justice, as it says.
Yeah, absolutely. Absolutely. That's the main criticism of unpublished opinions. The problem is, as she points out, the problem is that the modern caseload is so much heavier than it's ever been, that courts would simply grind to a halt without unpublished opinion. So not being able to designate as unpublished is not a workable solution. And the judges are really left to police themselves. What are the ways in which she identifies the ways in which judges can write persuasively? And by writing persuasively, I mean in ways that they can craft an opinion to bolster the result rather than crafting an opinion that leads to a result. What are the things that she identified that judges can do? Yeah, Tiffany?
Can you hear me?
Uh-huh.
I think she mentioned there being like a symbiotic relationship between writing and substance, like legal writing and substance.
Mm-hmm.
So they have to basically mesh the two and come up with, I don't know how to say. I know what she wants to say with the symbiotic relationship. I just don't know how to put it in my own words.
Okay.
Maybe somebody can help me. I don't know.
What else? Yeah, Catherine.
I guess what I focused on initially, what she was saying, how the justices lay out the fact pattern and how they order the facts in a way that bolsters their opinion.
Yeah, that they craft a story. And that's something that we know that lawyers do, that a good lawyer should be able to take the facts as raw material and from those facts construct a narrative that supports the argument. But what she confirms is that judges do that too, that judges, having voted on a case and decided on a result, and not having the time to let the writing lead to the result, that they really don't have the time on each and every case to, come up with a preliminary vote, start to write it, discover it's going in a different direction, and then have to go back and re-vote. So instead of doing that, they sort of they make it work. They have the result that they voted on, or if it's a trial court judge, that the judge has decided on, and then they draft the facts so that it bolsters the result. So judges are involved very much in writing persuasively, because not to do so takes away one of their tools for judicial efficiency and managing their caseload, which is coming to a decision early and then writing an opinion that supports that decision. What are some other things that the judges can do to get to the result that they had voted on or that they had decided on? Jacqueline?
I highlighted the labeling the product, and basically what I think she's trying to say is just like get to the point. Just say exactly what you mean. Don't go into extreme detail, because that's one of the reasons why they have unpublished decisions, because it's such a heavy caseload that making the opinion and writing the opinion takes so much time.
Mm-hmm.
That's one of the reasons why they just unpublish it, because it's less time to just say, here's the decision.
Mm-hmm.
So she says just write exactly what you mean.
Yeah, exactly. Labeling the product. What's another strategy they use? Yeah, Chris.
I think it said that they use tone in their writing, and specifically they were talking about dissenting opinions, where they use the tone to show that maybe that they didn't convince their other judges, and maybe they're troubled about the outcome that came.
Yeah, so in the dissents and the concurrences, she points out that you're representing yourself. You're not representing the court, and so you can use tone as a way to distance yourself, as a way to put distance between the opinions that you write and yourself as a jurist, and what you think was a bad or a poorly reasoned decision. Yeah, Rachel.
Was framing the case one of the tools, and just characterizing everything to support your fact finding?
Yeah, so what kinds of things can you do? One of the ones that we identified was constructing the facts, but framing the case, that's all about persuasion. And that's where she talks about persuasion the most. So one of the things that you do in framing the case is to craft your narrative so that it supports your result. What are other things that you can do to frame the case, Rachel? Oh, you're still muted. There you go.
Compare the factual accounts and just construct the facts so it goes with all your elements.
Yeah, but besides drafting your narrative so that it dovetails with your law, what are some other things that you can do? Jacqueline?
One of the other things that I noted is that she states that if there are any issues or discrepancies between like what they want as rule, just to market dicta. Like if you're pressed for time basically and you're having trouble, I guess, like figuring it out and panning it out, and you don't want to go through the whole figuring out whether you want it to be a rule or which way you want it to lie, basically just label it dicta and it's all good. And I thought that was a good technique if you're pressed for time, which makes sense, but it's kind of like, why even put it in the case then?
Why would you do that? Why would you include it if you're not going to include it in a way that is precedential?
That I mean, it gives future courts something to look at and say, oh, well, this is where they were thinking, this is the road they were going down. Because I know a lot of times dicta is cited in other cases, it is used.
Yeah.
It's obviously not weighted heavily. So it does help future cases see where past cases were, and it also helps when different fact patterns are applied different ways. But if the whole reason you're doing it is because you're pressed for time, then why do it? Because it doesn't seem like you're getting a good work product out of it. You're just throwing words into a case.
So again, let me ask you guys again. So then why do it? Why do it? Yeah, Tiffany? Why include an issue that you know going in you're not going to flesh out? That you're going to say, today we are not going to address X. We leave that for a future case. Why say that?
Well, two things. I know that in moot court we use dicta to, like, let's say we don't have a strong case, we'll use the dicta to flesh out or support the case that's not in our favor. And then if we don't, if we see dicta and they don't want to rule on the issue, we assume that they don't want that court doesn't want to tackle that issue. They want to leave it for another court, or that's how I interpreted it. They don't, especially if it's like a big issue, they don't want to be the ones ruling on it. They want a better set of facts or a more fleshed out record to handle that issue.
Right. So there are things that they communicate through dicta. Other than just, and there are uses for dicta other than just sort of a time-saving measure. So one is to signal we don't really have the facts here to do what we've been asked to do and what maybe we would like to do. But if the facts were different, then this is what we might say. And so it's sort of a way to communicate, here's the case you need to bring us if you want us to rule on this, or a flag to people who have cases currently that even though we didn't rule on this, here's something you can use. This supports your facts even though we didn't have them. So it's a way of signaling some information. John, yeah.
Yeah, I'm just kind of going along with that. I believe they said that it was a way for a judge to be candid in the sense that he knows that it could be like a close case, or he does have some doubts about which way he's leaning, or he can also basically reveal the consequences of the way that he's leaning, things like that.
Yeah, absolutely. Again, to communicate to someone, we're giving you some precedent here, but we're not really happy with this 100%. We are flexible on this. There's some room to maneuver here if you needed to. What are some other techniques for framing the case that the court can use to bolster their result? Yeah, Katie.
I apologize in advance if I freeze. I'm using my Surface, but setting the standard of review.
Yes, setting the standard of review. We talked about week before last how the standard of review is sometimes fixed. There's nothing you can do about it. But sometimes the standard of review is malleable. Sometimes there are a couple of different standards of review that you can choose from. And depending on which standards you use, you change the result. And so one of the ways the court can frame the case to bolster a result is to choose a standard of review that gets to that result. Another way they can do it, I told you guys about the article I'm writing about the speedy trial cases in Louisiana, that the way they got to their result was just to leave standard of review out completely. There was no way to include it and get to the result they wanted, so they just skipped it. Every single one of them just never mentioned standard of review. So standard of review can be a very powerful tool, or it can be overlooked. And I would say most of the cases that we read, there's no mention of standard of review. Sometimes that's because it's uncontroversial. Sometimes it's because it just doesn't help the judges get where they want to go. Some other strategies that they can use to frame the case have to do with the law that they use, telling the story in a way, and this is what we're going to see on Thursday with Shuttlesworth and Walker, that if you tell the story one way, that implicates one set of legal principles, but if you tell the story a different way, that implicates a different set of legal principles. And so the court, by matching, and I think one of you said this already, by matching the story to the related legal principles can bolster the outcome. So the court doesn't necessarily accept that the issue is what the parties say it is. The court can look at it and say, no, the issue here is, it's not this kind of action, it's this kind of action. And while they can't go too far astray, I mean, they've got to stick with what was preserved and what was raised for review, they still do have a great deal of discretion in how they frame those issues. And then finally, choice of precedent. She mentioned, and this was something that was surprising to me when I first read this article, that judges have their little pet areas of law that they either want to use every time to resolve everything, or they never really want to touch. They just want to, they want to leave that area of law exactly the way it is. And so they don't want to get too much into those issues, lest they have to change the law or interpret it or expand it. But then there are some things that every time they get a chance to address that issue, they want to find a way to do that. And so that was one thing that was surprising to me, that they have their precedent that they like, they have their issues that they like, and they have their precedent that they don't like. For example, she gave the example of Korematsu, which is the internment of the Japanese in World War II. And, she said nobody wants to touch that. Nobody, it's precedent, it's out there, but nobody wants to use that for anything. So that was interesting to me, that judges really have sort of their go-to precedent. So these are the things that she said the courts could do to be persuasive, to get to a particular result and justify it. And that's what persuasion is. Persuasion is having your idea of what the result should be, and having someone else agree with you that that's the result. And then the things that you do to get from the beginning to the end, that's persuasion. When you move somebody from one position to another position, you've persuaded them. And so these are the techniques they use. So the question is, who are they trying to persuade? Because we know who lawyers are trying to persuade. They're trying to persuade judges. Why did judges write persuasively? Who did they have to persuade? Tiffany's getting all the participation points.
I'll take a stab at it.
Great.
I would think they're trying to persuade the lower court judges to rule a certain way, or they're trying to persuade.
Well, now, higher courts don't have to persuade lower anything of anything, right? There, we've got a hierarchy. We've got litigants, we've got lawyers, we've got trial judges, appellate judges, higher court judges. You only persuade upward.
Got it. Okay, so I'll take.
You don't ever have to persuade downward.
Would it be that they're trying to persuade the people who got them into office, that elected them as judges?
Absolutely, absolutely. When you've got an elected judiciary, that's one of the groups they're trying to persuade. And you can see how, with an elected judiciary and the need to satisfy constituents, that if you're going to do something that you think your constituents might be unhappy with, then you might use some persuasive techniques to make that pill go down a little bit easier for them, or to try to persuade them that this result is in fact consistent with their interests. Catherine. Oh, got to unmute. I got you.
I think I remember reading that sometimes they want to persuade the legislator for the future to change a law, so that they don't make the same mistake twice when creating other laws that are similar to that, or when it's up for renewal, or if they have the option to amend the existing law. Right.
Yeah, absolutely. They oh, that's so funny. My video just cut out, and it really, so absolutely. They want to persuade the legislature, if they've got a law in front of them that they say is unconstitutional, they want to urge the legislature to not do that again. They want to urge the legislature to avoid that problem again. So that's another constituency. Rachel?
I was thinking other circuits, maybe it's an issue this is the first time it's being dealt with, or maybe it's split somewhere.
Absolutely. When you've got a circuit split, or when it's a case of first impression, you might be trying to persuade sister courts to come along with your view. Absolutely. Yusun.
I remember from this article, judge want to persuade their colleagues and the public that they are moving law in the right direction. Sometimes they want to explain why they came to a particular decision.
Right. Yeah, absolutely. One of their big audiences on an appellate court, and the Supreme Court also certainly works this way, is that if they don't have a majority for a decision, then they haven't really done their job. When it goes to an intermediate court or a high court of last resort, their job is to resolve issues. And if they can't get a majority of votes, they haven't done their job. They've spent a lot of time and a lot of effort, and they haven't really done anything. And so they want that majority. And so they make compromises to get to that majority. And so sometimes a judge might write an opinion to appeal to the other members of the majority so that they don't lose votes, and perhaps even to try to take into consideration some of the concerns of the dissenters to try to get them to switch their vote once the opinion is drafted. So they draft with that constituency in mind to move them from a decision not to join the opinion to a decision to join the opinion. Any other constituencies you guys can think of? Alyssa?
Yes, I was actually going to say that I think that they draft for citizens to show how the application of law kind of transcends all individuals. So it's just...
Yeah, one of the things that judges are always trying to persuade us of is that they are impartial and that their decisions are fair. And so they go to great pains to draft decisions that appear as though they looked at the facts, they discovered what the facts were, they applied the facts to the undisputed applicable law, and articulated the result. They don't want the public thinking that they come to a result and then they just figure out how to get there later, although that's really a lot of what goes on. So yeah, they're trying to persuade the public through their rationale and through their application that these are impartial decisions. And one thing that's a really important takeaway from this is judges are very good at that. Judges are very good at crafting a narrative, applying it to a dovetailed legal theory, and getting to the result, and having it look like that's just the way things unfolded. And that's one thing I think that advocates can really learn from judges, because good persuasion is invisible persuasion. If it looks like you're trying to persuade, you failed. Once the reader has identified your attempt at persuasion, you have failed to persuade them. And so one thing that judges are very, very good at is making it look like this is just the result you get when you apply these facts to this law. As advocates, that's what we want to do also, for two reasons. One, we don't want to seem like we're trying to push the court, because courts will resist that, and we don't want to do things that are over the top from an advocacy standpoint, because the judges just feel manipulated, or they really resist against that, or they really resist that. And so by presenting things, by crafting our narrative as lawyers and letting that dovetail with the legal theory, it looks like we're just saying to the court, listen, we just did what you do. We looked at the facts, we applied it to the law, and this is the result. It just happens to support my client. My client is on the right side. If you're a really skilled advocate, you're just going to look like the luckiest son of a gun that ever lived. You're not going to look like you ever have to do anything to win. It's going to look like you just have the great cases all the time. But great cases don't walk in the door. Great cases are made by the lawyers who advocate. So that's something to keep in mind. That's something that we can definitely learn from judges. Another reason that we want to do that as advocates is because that's what the judge is going to have to do. When the judge writes their opinion, they're going to have to make it look neutral. So show them how they can do that. Show them how they can do that. Okay, so we've identified that judges have constituents, and they have a need to justify their opinions in a way that portrays them as impartial and intelligent. So the judges undisputedly shape the opinion to to bolster the result. Okay, so we're going to talk now about just persuasion in general, and then hook that back up with opinions toward the end of the night tonight. So here's what I'll tell you about this and what we're going to do on Thursday. What we're doing tonight and Thursday night is really a very compressed version of what I do in advanced persuasion. And so if you're interested in developing this piece of it more, which clearly I think is critical to advocacy because I teach it, but if you're interested in developing this piece of it, we are only going to scratch the surface this week. I mean, barely scratch the surface this week. So if you're interested in learning more about that, I teach advanced persuasion every summer. And this is what we spend the whole course doing, is talking about persuasion and getting into really nitty-gritty techniques. Tonight, we are really just going to skim the surface. So the chapter that you read from Michael Smith, what are the three components that he identifies as being necessary to effective persuasion? Because now we know that judges need to persuade. Let's talk about what are the tools that we have as judges, not just crafting the facts as a narrative, making it dovetail, but specifically, what are we trying to achieve that way? How will we know when we've done that successfully? So what are the three components of persuasion? Yeah, Alyssa?
He mentioned logos, ethos, and pathos.
Absolutely. And what are those, Alyssa?
Well, pathos was persuasion, like trying to, I can give you an example. He said there's two, so emotional substance and media mood control. Mm-hmm. And the emotional substance would be like persuading through emotional substance and just trying to elicit a response from an audience, essentially. Okay. And then the media mood control would be to use an effective medium. So like using humor in an advertisement to try and, get individuals to watch it for the funny and amusing effect that it poses. Okay. And one of my very favorite examples of media mood control is a Hulu ad that Alec Baldwin did. I don't even know, like maybe 10 years ago already. It was the very first or maybe the second Hulu ad. It debuted on the Super Bowl. So if you get a chance at some point, look at the Hulu Super Bowl ad from God knows when with Alec Baldwin. It has really nothing to do with Hulu at all. It's just funny. It's just funny. And so, that Hulu ad came out at a time when Netflix still largely dealt in DVDs. And so the idea of streaming was still pretty foreign to everybody. And so they weren't trying to explain to you what it was. They were just trying to get you interested enough to go to the website and then investigate on your own what it was. And that was a great example of media mood control. They used that pathos to persuade by making you associate Hulu with a particular positive emotion that you had. So that's one example of media mood control. And then emotional substance is communicating something in a way that makes a reader sympathetic, or both of the media mood control and emotional substance are also communicated in part through as it suggests, through the specific medium, whether it is a document or an oral argument. You can use pathos with the medium of the message, not just the message itself. And then finally, ethos, Alyssa? Yes, so ethos would be like efforts on the part of an individual to establish credibility. So if there was an advertisement, stating like, I'm trying to think of an example. I know that there were a few, like clinical testing. Like if there was support through clinical testing, that would be an example of that.
Yeah. So let's talk about then, let's move this outside of the realm of advertising, and let's combine what you've learned about ethos, pathos, and logos and move it into the realm of analytical writing. So how would you demonstrate logos in an analytical document like a brief to a court? Anybody? Yeah, Alyssa?
Precedent, like cases.
Yeah, using case precedent is a way to demonstrate logos. Chris?
I was just thinking the structure of your writing would help appeal to the logical side of the audience.
Yeah, absolutely. The way that you organize your document as a whole, and the way that you organize the individual sections within. For example, telling a story in a chronological order in a way that the reader can follow. Using the basic analytical structure for an argument that goes by a bajillion different names, but I use CREAC in my class. Some people use IRAC, some people use SYRIAC, some people call it, there's all kinds of different things. But whether you call it, CREAC or you call it a monkey, it's the same thing. And it is a stock organization that we use in the law. We start by forecasting a conclusion, stating the rule, illustrating the rule, comparing that illustration to the unresolved case to show the connection, show how it connects to precedent, and then restating the conclusion at the end. It's a basic analytical structure. It's the same for judges as it is for lawyers. And you'll notice that really well-written opinions don't leave out pieces of that they include the rule illustration and the comparison of the facts, because it is a logical way to write. How do we demonstrate pathos in a legal document? Tiffany?
In moot court, we use the theory of the case to appeal to the emotions of the judges and to, whoever we're arguing in front of. So we try to use the facts and we frame them in a way that is more appealing to us. And, this case is about, upholding the fundamental principles of freedom of speech, stuff like that. Right. So I feel like that appeals, that's a way of persuasion.
Yeah. So with pathos, one of the things, when we appeal to values, when we appeal to morality, when we appeal to things that evoke a reaction, an emotional reaction, one of the things that's always a winner is appeal to our love of children, appeal to our instinct to protect children, appeal to patriotism, appeal to family, appeal to, in a lot of cases, appeal to capitalism as a uniquely American value. So those are all pathos appeals that you frame it in terms. And what Tiffany's talking about, theory of the case really breaks down into a factual theory and a legal theory. And the factual theory piece is where your pathos comes in. It's how you want your reader to feel about the client, the claim, and you as the advocate. And so when a judge is writing, the judge wants to elicit sympathy for the winning party so that the reader is rooting for the winning party and is happy when the winning party wins. And the judge is also trying to create positive feelings about herself as a judge, as a lawyer, as a scholar. And so, in fact, all of these operate on both levels. You're persuading about yourself as an advocate or as a writer, as well as persuading about the argument. And so the author has to demonstrate ethos, pathos, and logos, and the document, the facts and the law all together have to demonstrate pathos, ethos, and logos. Okay, with regard to ethos, how does ethos demonstrated in an analytical document? How do you demonstrate in a legal document that you are a credible writer and that your analysis is a credible analysis? Catherine?
I think precedent would be the biggest way to show that you're credible, because you're relying on authority that came before and that hasn't been overturned, and that is similar to the facts at hand.
Okay. So yeah, an appeal to precedent demonstrates that your argument is credible. Chris?
I was going to say, going back to what I said, also applied to logos, just your overall writing structure, sentence structure, just everything, the whole enchilada.
Yeah, absolutely. And he identifies in later chapters in the book that ethos in particular is incredibly complex. That ethos breaks down further into 3 traits. One is intelligence, the other is character, and the final one is goodwill. Intelligence breaks down further into 10 different characteristics. Character breaks down into 5, and then goodwill is your basic attitude that you demonstrate toward the court, toward your client, toward the opposing party, that you are operating in good faith, that you are operating not from an emotional level, but from a professional level. And so those are the 3 traits of ethos: intelligence, character, and goodwill. What are some other ways you can demonstrate ethos, Katie?
You can do it by, if there's a weakness in your case, if you discuss that openly, as opposed to letting the other side say it and you not bring it up at all.
Yeah, absolutely. Absolutely. So in that way, hold on. My video has completely frozen. Okay, it's all back. I don't know what's going on. Like, the internet seems to be slow everywhere tonight. Gremlins and the internet. So yeah, absolutely. So these demonstrations of ethos, pathos, and logos are what will make an opinion persuasive. So when my stuff freezes, does the audio keep going? Okay, great. That's fine. So Judge Wall talked about about framing the case. You want to do that using the parts of the opinion that she talked about. You're going to frame the case by telling a story in the facts, by identifying a standard of review that's favorable, by dovetailing the law with the facts, and then doing all of that in a way that bolsters the final result. You know whether or not you've done that artfully by using ethos, pathos, and logos as your standards, okay? Because as you can imagine, it's very easy to tell a story that supports the result in a way that's very one-sided. But that's incredibly problematic because you lose credibility when you do that. You hurt your ethos when you tell a story that's one-sided. And so with each of these framing opportunities, you want to keep ethos, pathos, and logos as sort of your guides. To start learning how to do that, you want to start identifying ethos, pathos, and logos in opinions that you read to see if the opinion is persuasive. And the opinion is persuasive if the result seems logical. If the result seems logical and not contrived, then the judge has succeeded in persuading you that the result is correct. Okay? So what we're going to do now is I'm going to put you guys in breakout rooms together. I would like you to look at the Merrick Garland opinion. Merrick Garland is the president's nominee for the Supreme Court right now. Who the hell knows what's going to happen with that? But one of the benefits of having Merrick Garland be the president's nominee right now is that because this confirmation process is dragging out the way it is, there's been a lot of opportunity for scholars to pull together his body of work. And Merrick Garland is, from everything I have read of what he writes, a really excellent jurist. He's a really good writer, and he's very persuasive in that you don't feel persuaded. You just feel like the result is correct at the end of the opinion. And that is the hallmark of good persuasion, that you don't feel persuaded. You just feel like you've been presented with the answer and the proper justification for the answer. So what I've put on Twin for you guys is a short excerpt. I know it's 4 pages, but it's 13-point font. And it's a short excerpt of an opinion. It just, it gives you the procedural history and the facts, and then just starts to get into the analysis so that you can start to evaluate and see what are the characteristics. So you can look at it and know that it is a good opinion, but that's really not enough. If you're going to write good opinions, you've got to know why a good opinion is good, and you've got to know why a bad opinion is bad. You've got to be able to pinpoint it and articulate it, or else you can't do it. If you can't identify what makes it good, you can't write a good one on purpose. You can write a good one on accident, but you can't write a good one on purpose, and that's what you guys are trying to do. I assume you want to be on purpose good writers, not kind of hit and miss accidental good writers. So I'm going to put you in the breakout rooms. Take, I'm going to say take about 10 or 15 minutes, whatever your group decides you need, to read through the opinion and just make some margin notes, or make some, notes on if you're doing a computer draft, make some notes about where you find ethos. So for example, where do you find that he exhibits traits of intelligence, that he's a good researcher, that he's a good writer, that he's a careful writer, that he's a deliberate writer, that he's organized? Where do you see positive pathos, things about the opinion that make you feel good, either about the argument, about the winner of the case, or about him? And then where do you find logos? Look at the structure and see what you think about the structure. Is it a good structure? And then we'll come back at about 8, and we'll talk about that for the last 10 minutes. And then on Thursday, we'll pick up with Shuttlesworth, Walker, Broomfield, and Kane, and look again more specifically at how these techniques work together the way that Judge Wald spoke of. So let me send you guys. Anybody have any questions about anything before I shoot you into those rooms? Okay. Hold on. 30 minutes. So I'm going to put you guys in four rooms. Okay.
My computer just kicked me out. Like, shut me off. I was with Jeff and Tiffany, I think. You're muted. I can't hear you.
Okay. So you don't have.
I was in a breakout room and then my
Right.
just died, closed. I don't even know.
Okay. So my computer was right in the middle of doing something. And so I think, okay, so I need to make it stop doing that and then start doing this. Okay. That.
I'm sorry.
No, you're fine. You're fine. Listen, this is going to come up again. Better that I know how to do it.
Yeah. Thank you.
No, you didn't do it. Okay. Breakout room. Okay, so I've got the breakout rooms. Ooh. Okay. Hold on. My computer is frozen up. I don't know what like.
I don't know. My laptop wouldn't work, and then my Surface, it's just.
That's crazy. And last night, Nikki was having problems, and somebody else is having problems. Okay, here you go.
Thank you.
You guys were right on time.
Some people might not know how to get out of it, because I know I had to ask Alyssa how to get back into this room.
Oh, yeah. Huh, that's interesting. I want to do something real quick. I want to test something with these rooms. I'm not going to zap you back into them, but I want to see if this shuffles the rooms. So hold on. That did shuffle the rooms. Okay. Because Professor Nowak was trying to shuffle the group rooms. She didn't want the same groups each time. And Professor Graves and I didn't know what to tell her, and I just found the button that does that. Okay. So Merrick Garland's opinion. Let's look at it in terms of ethos, pathos, and logos, and let's start with ethos, because if you don't establish your ethos as a writer, whether you're a judge or an advocate first, everything else starts to go downhill from there. So what evidence, or rather what did he do in his writing that gave either him credibility or his argument credibility? Yeah, Jacqueline?
The first thing that we noted was that the literal first sentence was that Antonio pled guilty. Like, he made sure the first sentence mentioned that he pled guilty. So it's like foreshadowing and showing the mentality of the rest of the decision.
Okay, so and how does that bolster Judge Garland's credibility?
He goes further into explaining it. On page 3, he goes through all of the basically everything that he pled guilty to.
Yeah.
And shows, gives all the citations and everything.
Yeah. Tiffany?
To add to what Jacqueline was saying, the way he laid out the issue, he was very clear and concise. He said, first, he pled guilty to XYZ. Second, he basically laid out the arguments like a roadmap. And then he cited to the Booker case, and he explained why the defendant misinterpreted the law and went into that.
So how does that bolster his credibility?
It's showing that he was thoughtful and that he went into the research and he knew the precedent, he knew the case law, and he used that case law to support his argument or to support his findings.
Okay, so it demonstrated that he was deliberate, he was organized, he was careful, that he was thorough in his research. Okay. What other evidence did you guys find of Judge Garland's credibility? Yeah, Catherine?
We noted that he didn't seem biased at all. It was very unbiased. He didn't feel like he was coming from it wasn't his personal opinion. It was based on facts. I guess that would go to logos, the logic.
Well, no, I mean, the impartiality goes to ethos, that he meets the expectations that we have that a judge will be impartial.
Right.
Yeah.
We all agreed that the language, the rhetoric that he used was to the point and unbiased.
Yeah. Yeah. There wasn't a lot of, of pushy language that tried to steer you in a direction. It just seemed like he was laying everything out.
Right.
What else? What else contributed to his ethos? Yeah, Rachel.
We said his tone and the mood of it gave him credibility because it wasn't really aggressive.
Mm-hmm. Okay. How would you describe his tone?
I guess like Catherine said, neutral.
Okay, so in neutral tone. What about pathos? What did he do to elicit positive feelings about either the opinion or him as a judge or maybe someone in the particular case? Jacqueline.
One of the biggest things that we noticed was, like you mentioned before, the patriotism. On the second page, he says that Braz conspired to defraud the United States, and it's just like not just D.C. but the entire United States, and it just seemed to like play towards patriotism and the emotions of what he did.
Okay, so it's a really subtle way. I mean, the crime is defrauding the government, but he chose to use United States as his label for the government, and that's an intentional choice. And you're absolutely right; it does sort of ramps things up, and it is sort of an appeal to patriotism. This is a bad guy. He's defrauding all of us. What else? Let me ask you this. Do you have positive feelings about him after reading this opinion?
Mm-hmm. Yep.
You don't? Jacqueline, why do you not?
It just shows like he's got 17 counts against him. He defrauded the United States.
No, I mean the judge. I mean Judge Garland.
Judge. Okay. Yeah. Yes, I do have positive feelings against him.
What did he do? Okay, what did he do to? Let me go to Chris. Chris, what did he do to elicit those positive feelings?
I was actually going to say something else, but let me think for a second.
Okay.
To elicit positive feelings for him.
Uh-huh.
Well, I guess just fulfilling the ethos, pathos, and logos for me. I kind of believed what he was saying based on the way that it was, structured and the tone of it, I guess, and then just really the credibility, I guess.
So you felt like you could trust him, that his analysis was trustworthy?
Yes.
Okay. And so by giving you a clear, well-reasoned argument, that made you feel good about him and then better able to accept his argument.
Yeah, I would say so.
Yeah. Yusan.
When I read his opinion, what I felt is he didn't want to irritate or offend the reader with a very neutral tone. I totally agree with Catherine, and he not emotionally involved, and he's a very intelligent legal writer because his opinion is very organizing and analytical, and his writing is his opinion was described by using simple, understandable language compared to other the other judge's opinion. So
Yeah. And so by establishing the ethos, by being organized, concise, using clear language, being thorough analytically, that also contributed to the positive pathos, meaning you felt good about relying on his opinion and about reading his opinion, and may have even found yourself, it sounds like some of you, wishing that you had more opinions like that to read instead of some of the ones that you do have to read. What about, let's see, does anybody have anything to add to pathos? What about how you felt about the defendant? How did you feel about the defendant? Jacqueline was not impressed because he had been indicted for 17 counts. Chris?
I think the term of art for my group was that he was an asshole.
Very nice, very nice. That is in fact a legal term of art.
And we discussed, like Jacqueline said, about the 15 count indictment that they, most of them they threw away, and it was within their authority to sentence him within the range, and they actually gave him the minimum, and almost like he's greedy now, coming back wanting to get less than the minimum, which was what he got in the first place.
Right. And what's interesting about that is those aren't strictly speaking legally relevant facts. Some of those facts are not necessary to reach the result, but they set us up as the reader to accept the decision against the defendant in the end. That things could have been so much worse for this guy that we can all feel good about what happened to him. What could have happened was so much worse than what actually happened. And that's a technique called priming. It's called door in the face, where you go big at first and show how bad things could be, and then back off and show the end result where the reader goes, oh, well, that's not nearly as bad as what I thought was going to happen. And so if you just addressed, for example, the 8 or the 7 counts that were remaining, then the difference between, what he could have gotten on those counts versus what he ultimately got is smaller than if you add in all of the counts. And so that's a way of priming. But it didn't look like priming, right? Because he didn't push it. He didn't say, this guy is greedy. He didn't say, this guy is really pushing his luck. He didn't say, the courts have already cut him a lot of slack. It's the way he laid it out, where it looked like it was just very matter of fact. But he used priming, which is an ethos technique, very, very well. Because by the time, you got to what actually happened to him, it was like, oh, well, he needs to sit down because things could be a lot worse. And if he doesn't sit down, things might get a lot worse. What else did you guys think? Anybody else have thoughts about the defendant? Another technique that he used in addition to priming, or really, I guess, sort of as part of the priming, is he provided a lot of detail about the counts. I mean, a lot of detail about the counts. And all of that detail wasn't, strictly speaking, legally relevant. It wasn't all necessary to reach the result. But it all looks relevant and it all looks fair because that's what he was charged with. That's what happened. So he used level of detail as a technique and really it hits on 2 areas. The level of detail contributes to his credibility by showing that he understands what happened and he has a handle on things, and then it cuts against the pathos. Okay, so I see we're over time. We're going to stop here, and we're going to pick up with this on Thursday. So we're going to start with the logos of this Merrick Garland opinion, and then we're going to move into the ethos, pathos, and logos of the Sam Kent excerpts that I gave you. And so between now and Thursday, if you would read those excerpts and jot some notes down about the ethos, pathos, and logos that you see in those excerpts, and I think that's it. And then we're going to go into Shuttlesworth, Walker, Broomfield, and Clark. Any questions? Okay. Oh, two things I wanted to tell you. I'm sorry. One, if you didn't see the note at the beginning of class, I've posted the grading rubric for the judicial opinion under the cases for the Court of Appeals. So it's there with all of the case briefs. One thing I'd like you to do between now and Thursday is look at that and notice how it relates to the ethos, the pathos, and the logos. That what I'm really checking is not only have you written a correct opinion, but have you written a persuasive opinion in that it hits, it mentions all the things it needs to mention, it's logical, it doesn't go overboard in evoking emotion, it contains all the information it needs in an order that's accessible to the reader, and then a lot of ethos in the last section about the writing. And then the last thing, which I knew I was going to forget when I said that thing about the grading. Oh, the last thing, the NYU Law School has a website called the Merrick Garland Project. So as you're thinking about how to write your opinions, if you want examples of some really well-written, very impartial seeming opinions, that website collects some of his very best opinions, and there's a little bit of analysis about the opinions. So that's a good place to look for really nice, clean opinions. Okay. I apologize for keeping you over. I'll see you on Thursday. Bye.